Warm good morning to everyone and welcome to the next research webinar series. Today we have an eminent and renowned speaker in Dr. Anuradha Maheshwari. Before we start the session for today, shall we begin the day with a silent prayer? Thank you. Thank you everyone for joining us. We have with us Ms. Soumya, who will welcome the speaker for today and take over the proceedings. I welcome Soumya.
Thank you, ma'am.
Hello.
Good morning, everyone.
Hello, can you hear me? Vicky madam.
Yes, Father, you're audible.
I think, did you open any two system? There a lot of howling is there. You're not able to hear properly.
Is there an echo?
Yes. Is any two system is open there in the same room?
Father, is that fine? Is it fine now?
The echo is there.
Is it? Yeah, it's still. I think, Father, a couple of mics are on. Am I audible now? I think it is taken care of. So, good morning, everyone. It gives me immense pleasure to introduce and welcome the speaker of today's session, Ms. Anuradha Maheshwari, an eminent corporate and intellectual property lawyer who handles all commercial and real estate transactions, POSH and human rights related matters. She is a founder, Lex Mantis Advocates and Legal Consultants, a member, Board of Trustees, Committed Communities and Development Trust. She holds a master's degree in international and constitutional law from the University of Mumbai. Her core area of practice includes managing and prosecuting patents, trademarks, designs, copyrights applications, designing holistic protection strategies, negotiating and drafting technology transfers, licenses and media contracts and licenses. Ms. Anuradha has advised and managed IP dispute and has engaged with reputed senior counsels in litigation matters. She has advised many startups and SMEs on entity structuring and incorporation, structuring corporate deals, and legal due diligence. She is a very established trainer and has been regularly conducting workshops, lectures in IP and POSH mainly. Her clients include established corporates, large M&E houses to technology and manufacturing firms, and startups, universities and online education providers, F&B outlets, fashion and jewelry industries, including some overseas. Madam, it is indeed an honor to have you here as a speaker for today's session. Before Ms. Anuradha starts the session, I request all the participants to kindly mute their mics and also kindly engage during the session if you have any queries or concerns or doubts, please send your queries and concerns in through your chats. I also thank Dr. Father Josie George, Director and Dean, Christ University Lavasa campus, for giving this opportunity for the Center for Research in organizing the lecture series every week. And I welcome all the participants, all the faculty members and PhD scholars for the session. Over to Anuradha, ma'am. Look forward.
Good morning to all of you, and thank you so very much for inviting me today and giving me this opportunity to share some light on the topic of intellectual property, as we say. Father Josie George, Dr. Becky Thomas, Soumya, good morning again, and thanks once again. I'm going to start my session with a very interesting toy. I hope all of you can see this toy. We have all played with it. Have we or have we not? Anyone who has not seen this or not played with this particular toy? I don't think there's going to be one amongst you who will claim that, credit to say that you have not played with this toy. No way. So this is a very, very interesting toy, and this toy is called famously Rubik's Cube. All right. But what many of us do not realize is how this toy came to be, and surprisingly, how it ruled the world. It's not only a mere toy, but it went on to rule the world. So what was so special about the toy? I'm asking some of you, can any of you share your views on this toy, even on your chat screen? Any of you? Just to know what's so special about this toy. How did this toy come to rule the world? Would welcome your answers on this. Engaging and finding the right match. Yes, but is there a particular way that we have to find the right match in this particular toy? Is there something that we are expected to do? Any of you? Yes, it was used in most games as a challenge, an intellectual challenge. And what did we have to do in this particular challenge? What was so special about this challenge? Why was it so difficult? And I presume all of you here, all of us have found it difficult. And the level of the engagement in this toy was the level of difficulty. We were not able to, come to the right conclusion. And yes, like somebody has written, all the blocks of the same color must come together. Very true. But the biggest thing about this toy, which perhaps it may have not struck us at some point of time, or maybe at no point of time, was the fact that this particular toy was a rotating toy. It was moving on pivots, not one pivot, but multiple pivots. So each block could rotate, blocks together could rotate. So you could take, if I were to show you like this, I can take one entire block like this and rotate the same. So there could be multiple. In each of the ways, I could just find a way to rotate this toy. So the interesting thing was, a gentleman by the name of Endro Rubik from Hungary. He was an architect and a sculptor by profession, but he was into teaching classes. And there he wanted to show the students of that class how 3D movement takes place. So he wanted to show them through an object of art that, you could have a dynamic kind of a 3D structure. And then as he kept building on it, his thought process veered round to creating a structure which was full of opposites. Apparently, it must look simple, but at the same time, it had to be very complex. It had to have stability, balance. At the same time, it had to be dynamic. It had to look orderly, but actually, if you look at it like this, it was all quite chaotic. So he wanted to create a toy out of contrasts, and those contrasts he captured and incorporated it into this famous toy, which came to be known as Rubik's Cube. Now, when Rubik's Cube he invented, he was all of 29 years, but it almost instantaneously became a hit, of course, in Hungary, And then it went on to become a rage around the world. But in the meantime, he understood the potential of this particular toy, that it is something beyond the mere, average intellect of a person. So it required a lot of application of mind. It was very engaging, like somebody said, but it was also a kind of a challenge to get the better of the toy and bring all same colored faces on the same side. Therefore, what it showed very clearly was that there was a particular design. There was a method in this madness, as we call as a Rubik's Cube. And it had a lot of structural dimensions to manage this. And therefore, he decided to go for an intellectual property right in the name of a patent. So he files a patent in the January of 1975, and immediately realizing the commercial potential of this particular toy, the biggest toy company then in Europe was Ideal's Toy Corporation. And he said, okay, I'm going to sell the toy to Ideal's Toy Corporation. Now, when I use terms like sell or license, it's not just a mere sale, and it's just not a mere license. There are lots of aspects involved in this sale. So no sale is a simple sale. If I am selling to you, am I giving you away all my rights, or do I continue to hold some intellectual property? All of these things is what we will be looking at today through practical examples. That's what I'm going to try and make you understand this subject through various examples of inventions, of films, of television serials, to make you understand how the money flows from an intellectual property. So when Ideals Corporation took this particular toy, it then decided to rename the toy. So another level of intellectual property. And they renamed the toy to call it Rubik's Cube. Over 350 million, not one or two or not in thousands, but in million Rubik's Cube was sold then. Between 1980 and 83, 200 million toys were sold. And it, of course, to date is the top selling toy in the world. All right. So you can just imagine the kind of fame and credit that this particular toy has earned. But when somebody or something becomes so successful, there is a commercial success to it. So there is a lot of money that flows in. And the question is, who reaps those dividends? Is it the one who has created that particular property, as we call it, or will it be somebody else who has been selling that particular property, or somebody else to whom it has been licensed? So all these aspects have to be looked into when we are looking into intellectual properties. This toy became so famous that world cube associations were formed and cubic tournaments were formed all over the world. A film was made on this toy, or this toy was used in a film, and it became a kind of a theme within that film, and this was Pursuit of Happiness, after which again there was a demand for Rubik's Cube. Needless to say that Enro Rubik became a millionaire in Hungary, and of course, he was just one of those very, very successful businessmen of his times. Just to give you the kind of dimensions, the math involved in creating the Rubik's Cube. So it was 26 smaller cubes, 6 faces of 9, color of each, and 6 colors each, 43 quintillion ways to scramble. I just can't even think of it. What a mind-boggling figure to say that there are 43 quintillion ways to, come to arrive at the right answers for the Rubik's Cube. I'm not even getting into the whole thing as to what else the cube can do, but just to tell you all that this cube also became a source of bootleg operations or fake operations. Now, what do we mean by that? We mean that slowly, over a period of time, all over the world mushroomed fake Rubik's Cube or copies of the original Rubik's Cube or imitations of the original cubes. So that's what I have written over here. 50 million unauthorized knockoffs of the cube was created. And there are at least 10 million books explaining how the cube has to be worked out. Coming to the next thing, that is his intellectual property in this particular cube. So as I said, he filed a patent in Hungary. Then from there on, he went on to file a patent in the US. The US patent expired in 2000 after 17 years, after which the technology of the cube came into the public domain. From there on, others took, but what remained was the trademark in this particular cube, which remained with Ideal Corporation. So in 2012, Seven Towns now owns the Rubik's Cube. So Seven Towns company of the Rubik's Cube went after the people who were copying the Rubik's Cube. There was a copyright infringement, and it was clearly claimed that the layout of the stickers in the clockwise configuration represented the Rubik's copyright image and their product. So it's a huge, massive kind of a, intellectual property. It's a wealth of intellectual property, particularly there in the Rubik's Cube, one small little toy. If I were to ask you in a very simple way, therefore, how would you describe a Rubik's Cube? If there is one word or two words to describe Rubik's Cube, how would you describe it? Can anyone give me an answer? Describe Rubik's Cube, therefore. Very simple. Challenge? Yes, you're right. You're not wrong. But I want it to be a far more basic word than challenge. Fun? Yes, fun. Challenge. Game? Yes. Complex? See what I have written. It is a great idea. At the end of the day, if I were to consider Rubik's Cube, what we will say is that it was a brilliant idea. So that's what we come to. At the end of the day, if you analyze, and you will find that why is it that humans of all species have survived this long and this far? And the answer to that lies in the fact that there have been some marvelous breakthrough ideas which has helped man sail through, the periods of evolution, and we have reached where we are today. I mean, look at it. We are talking about a time when man is completely assaulted by the coronavirus. And the debate around it is that it's a man-made virus. When you're looking at a man-made virus, then you are talking about medicines, you are talking about vaccines, all of them great technology which have to all come out. They are all coming out of the process of ideation. And ideation and the human intellect is something so very unique to the human species. It is great ideas that have saved the world. And if you look at it, it's coming, or ideas are born out of an intellectual activity, which is nothing other than a labor of mind. So very typically, if you are looking at it, we have survived because the world has been a marketplace. And the world has been a marketplace because there have always been sellers, buyers. Instead of using the word goods or products, I'm going to use the word great ideas. So the buyers have been very demanding, and the sellers have been, please pay attention to what I'm saying, have been very innovative. They have been innovative because they have to stay ahead of the competition. If you do not innovate, you will perish. So every seller has been innovating over time, and they have come out with great ideas that have saved the world. So I've just captured some of the ideas into three baskets. The first one is absolutely revolutionary breakthrough ideas, milestone ideas, which have created complete change in the life of man. And then we have top innovations of all time, where you will find an overlap between ideas that changed the world and top innovations of all time. And I come to a far more, abstract kind of a thinking, which we call as design thinking examples, which is given on the last column. So the first, I always tell my students, does it ever strike you that man was not intended to wear clothes? So, when and how did man start wearing clothes? Very interesting. And the only answer to that lies in the invention of needle and thread. So earlier it used to be the adventitious roots which are used to come out of the trees, or plant fibers, etc., through which they used to make thin yarn kind of stuff and help to sew or suture things. So, for example, even in our Shushruta, it is written that earlier surgeries did take place, and they used a certain kinds of, ants to suture the stitches. So, these kind of inventions did not happen overnight. They happened through the ages. So these inventions are what changed man. So communication changed forever with the advent and the invention of the printing press. All of us know about the light bulb and how electricity saved our lives. We have the airplane, we have the computer. I've already talked about vaccines, automobiles, clocks, telephone. Look from Alexander Graham Bell's time to where we are today in terms of the cell phones that we are using and where technology has reached. Refrigeration, camera, you name it, and our lives are completely dependent on technologies today. But the issue that arises over here, are these technologies selling? And the answer to that, you know very well. We are paying heavy prices to buy cell phones, to buy laptops, to buy computers, to buy all kinds of fancy gadgets within the house or within the office. Because without those gadgets, we are unable to live our lives comfortably as we visualize it. So, therefore, the answer to that is, are we willing to pay the price? And we say yes. So, the question is, who should pocket the money that we are paying for those technologies? Very simple answer, very straightforward answer. Obviously, the creator of the technology. But herein lies the complexity. Many of you are researchers, many of you are involved, or you are students of a particular university. Now, if you are a student of a university and you come out with a brilliant idea, the bottom line is, who owns that idea? Can anyone tell me? You've done all the hard work. You've done all the hard work. Completely breakthrough idea. Not heard of, not seen before. And now you want to bring it out into the marketplace. So that therefore it means that you want to sell that idea in the form of a product to the marketplace. And you're right. It will either be the organization or it will be the innovator stroke inventor. Very simply, we say the creator should get the credit for a great idea. But on the other hand, there are organizations, there are individuals, there are partnerships which help aid and assist the inventor creator. Failing which, the inventor would not have been able to produce what she or he did. So therefore, the logic that applies over here is that credit of owning that idea and the product coming out of the idea should be given to the supporting individual, organization, institution, whatever we choose to call it, company. So all these, why are we saying all the pharma companies are so rich? Who is taking the patent on these on the medicinal technologies or that are hitting the world every other day? Every other day there is a development. Who owns the patent to those development? And the answer always is the pharma company, not the individual scientist. What the company does is hires individuals to work for it, and therefore the company will be giving the entire infrastructure of support to the individual to innovate, to think, to come out with those great ideas. So therefore it is very important to understand how the commerce will be working on it. So some of great design thinking ideas, I mean, none of you have ever thought of it that language has been a great invention. Look at it. Today we are talking about the science and grammar of language. There's been so much evolution in the language that was used in earlier times, in ancient times, and the language we are speaking today. And today we have a completely new language in the form of computer languages that are there, which are all technology language. One day they will become commonplace. So this is how all these great ideas have saved the world. We have some great design thinking examples, again, which have disrupted our lives in a very positive way. Suppose we look at something like an Airbnb. Saved costs, great economics, makes holidays so much more enjoyable. PillPack is something that you see today in terms of PharmEasy or all these medicinal companies which will deliver your prescription drugs to your doorstep. We have clean tech, we have IBM, they have all come out with different service models. These are all examples of great service models. Uber Eats has revolutionized the way food can reach your home. Today we have a replica of that in the form of Zomato or Swiggy, as we can see. Sulabh Sauchalaya has been a great revolution for India, great design thinking example of how to make it possible for hygiene and sanitation to reach the common man. And that has been a great success story because they have done what is called as the pay and use toilet model, and it's worked very well. So that's a great revolution that has taken place. Now I come to the next step. As I have created a great idea, I have created something out of that idea. So always remember, ideation in itself is not enough. I have to give. If I look at this, there was an idea in the head, and the idea then translated into this. While this is a product, we will say that this is a tangible form of the idea. So I cannot protect my idea just like that. People need to see proof of my idea, and this is the proof. The tangible form is the proof of my idea. So ideas in itself inside the head cannot be protected. What am I protecting? Except if I keep it as a secret. So I say, oh, I have a great idea, but I won't tell you. That's my idea. That's a secret. But on the other hand, you are saying, I'm not going to pay for your idea unless I have proof of what your idea can do. Show me, translate your idea on paper. And that's what we want all the time from people. Now, the question is, when I am translating the idea, I'm worried. Should I be worried? Come on. Who's going to tell me? I'm translating the idea. Should I be worried? I'm showing you what my idea is. I'm drawing it on paper. Can anyone tell me? Why should I be worried? Yes, you're worried that it will be copied. That's always absolutely theft. It is always the biggest problem. By nature, So there is a kind of a paradox here. While we talk about human evolution, you must realize one thing, that man would not have evolved to the great length man has actually evolved because man had a great ability. And that ability was the ability to copy. Look at all of you around. Are you wearing the same kind of clothes? Will anyone be caught wearing something completely different out of the box and come to a classroom? No. Classroom is a great place for you to understand homogeneity in a lot of things that we do. We do not want to be different. We want to be part of the herd. And therefore, I want to be accepted. And then I want to be like the other. So I wear the kind of same shirt you will wear. I wear the same kurta like you will wear, the same lungi like you will wear, because I don't want to be different. I like what you're doing, so you like what I am doing. So we tend to copy from one another. So this is a very important theory, that without copying, man would have not survived. So you always see examples of great copying going on at traffic signals, where one person comes with one item to sell, and by the next day there would be 10 of them selling similar kind of stuff with different colors and different designs, but it would be the same essential or basic item. So this is the problem, that we tend to copy. And because we tend to copy, we go to the next step. We tend to misappropriate. Misappropriate means your idea, I will go out and sell it as if I am selling the idea. So what should have gone to you as a benefit comes to me instead. Somewhere along the way, man realized, you must understand this is a very important legal concept I'm explaining to you, that property is not natural. There's nothing naturally as property. Even though we talk about inheriting property, these are all created by man. These are inventions of man. So, for example, we tend to say that man has created a lot of inventions. As people, I would request you all to all read Yuval Noah Harari as to how brilliantly he thought and he explains evolution in man. So all of these are all new constructs. So property has been, like for example, marriage. Marriage is not natural to man, but man created marriage just to create organization in the society, just to create organization in the family. The concept of wills, the concept of inheritance. Earlier, man was a nomad. There was nothing like a property. Man just settled where man felt like it and again traveled. So it was not something that went on. But over a period of time, man's need to travel outweighed man's need to settle outweighed man's need to travel. And therefore, when man settled, man said, I claim this territory or this land as mine till I'm here. That till I'm here then went on to become far more bigger, to say, oh, till my life, and thereafter my property will go to my children, thereafter it will go to my grandchildren. So we expanded on the concept of property. So what you own, it means what you claim. And therefore, legal boundaries were created to understand or make people understand what is ownership. So today, if I am saying this particular house is mine, I have title deeds to prove that this house is mine. Or if I say this car is mine, I have title deeds to say that this car is mine. I have proof to say that I have paid for this house or car, and therefore whoever was owning it earlier has transferred it to me. So the concept of property became very deeply entrenched in human lives and human systems. From that emerged another concept, and that concept was tangible property and intangible property. Tangible property is that which you can touch. Land, house, car, all of these tangible. I can touch them. So from there emerged another concept of movable property and immovable property. So land and house went into the category of immovable property, and goods that I could take with me wherever I went into the category of movable property. But in movable property, in the new age, emerged another concept of property, and that was intangible property. For example, stocks and shares. All of you are very well versed with what are shares. So you're buying shares of a company. Now, company is again another brilliant invention of man, because company exists only in paper, only on paper. There is no physical structure to the company. It is only a paper made structure. So you have created it on paper. So company, we always say company is born on paper and dies on paper, or today in a digital format. So what we are really doing is we have created an entity called as a company, and that we have in sort of imputed that entity with a lot of characteristics to resemble that of a human being, and then we at some point of time dissolve this entity, liquidate this entity. But while the entity is succeeding in the marketplace in terms of manufacturing, in terms of selling products, services, etc., the entity becomes very, very successful, and people want to back that entity. And how do they back that entity? They invest in the entity and buy shares of that entity. So if you can't see the entity, it stands to logic to say that you can't even see the shares. But you are trading in the shares. Shares are your property. So it's a movable, intangible property. That's what man realized over a period of time, that any great idea which has come out of my intellect is also an intangible, movable property, and therefore it should be treated as a property and should be given the kind of legal status befitting any other kind of property. So that is how man came to understand that ideas in inventions and innovations and expressions in signs and in symbol were also properties. So it was the labor of the mind that came to be attached with the property. So this is intellectual property. Intellectual property is the innovative idea behind the technology or the invention, or behind the expression, or behind the sign or the symbol, or behind the aesthetic look and appearance of goods. So any creation of the human mind which is locked in a tangible form is called as intellectual property. I repeat again, it is an intangible property because you can't touch it. You can feel the property. It is a movable property. You can carry it anywhere, wherever you go. It can be used and accessed and distributed and chucked out and thrown out of the window, but it is your property, and it is for you to do what you wish to do with your property. And in the final outcome of this property is that entire shower, the bundle of rights that you get from a single property. All right. So why this came to be and why intellectual property today has become a huge thing and a subject to be so talked about is because of the huge value that is attached to intellectual property. Before I go forward, just wanted to mention it to you. I'm sure all of you are aware of the newspaper items, various issues that are being discussed in public over what we call as patent waivers. People are petitioning the WTO, World Trade Organization, to consider a suggestion to waive patents so that vaccines become much more easily available. Now, what does this mean? What does it mean? Now, when we are saying waive patents, waiver means to give up. Now, when they are saying give up, what are they asking the WTO to make possible? Are asking is that WTO should request member countries not to enforce patents that have been granted to big pharma companies or research labs for the vaccines that they have invented. Now you understand. So, for example, we have the Covishield vaccine in India. The Covishield vaccine is an outcome of research that took place in Oxford. So the research institute involved is Oxford. Oxford collaborated, so some amount of funding must have come from AstraZeneca. So it's a Swiss company. Oxford collaborated with AstraZeneca, and together they have taken a patent on the Covishield vaccine. And thereafter, one of the first licensees that they have allowed to manufacture the vaccine is Serum Institute of India. So there was a kind of a tripartite agreement, or you can say three parties involved, and that's the success behind Covishield. So Covishield is not being given free. The vaccine, the government is paying for the vaccine. The manufacturer, Serum Institute in India, is charging what they think is justified for the vaccine, what they have got out of the license arrangement with Oxford and AstraZeneca. So I'm just trying to simplify for you things that are going on in the marketplace. So now they are saying, don't enforce the patent. The moment you stop enforcing the patent, automatically the price on the goods fall. So what the companies are, I can make it freely available. Otherwise, if it is a patented product, you can't transfer it freely. You have to charge the R&D cost that was involved in preparing the medicine. And I have to take permissions. I have to take licenses before I can manufacture it. So all these are problems with the patents that are there currently, which are impeding the production of vaccines. They're coming in the way of vaccine creation. So that's what they are saying, that stop it. Stop it right now, at least for 2 to 3 years, until we have tided it over the pandemic. And, thereafter, vaccines can be charged. So this is a thought. This is a thought to create a more free environment in the world. So just giving you the cost of stealing ideas and how much people have suffered. So in 2006, this is an example. This is very important example actually. Ford company, the famous car manufacturing company, suffered a loss of more than 50 million USD after an engineer copied 4,000 documents of the company into a hard drive and joined a competitor. And this is so common. We think nothing of taking material, of copying, of doing it. I mean, even while we are teaching, we find people copying our presentation, taking snapshots of our presentation, and promptly they will go into their own, and create a copy of that presentation. We do not think twice that we are stealing somebody else's idea. The US federal administration said that this is the scary part, that there are 520,000 counterfeit parts installed in aircrafts each year. Each year. It's not that up till now there has been so many counterfeit parts. They are saying over a study of so many years that these kind of counterfeit parts are being installed all the time. You look at India and you look at many other countries. India is not isolated in what I am saying. There are very active, thriving fake auto part industry all over the world. So car manufacturers come out with expensive cars. The spare parts of those cars are also expensive. Immediately, there is a parallel market, and that parallel market is thriving on creating fake auto parts of these famous originals. Same thing with the textile industry. Same thing with clothing manufacturers, same thing with handbag manufacturers, with jewelry, you name it, and there is always a parallel industry of copycat products. So that's the problem. The Equipment and Manufacturers Association cites that 1 out of every 3 auto parts are copied in the US. In India, auto counterfeits erode 30% of the market share. Fake drugs. Biggest problem is fake drugs. Fake drugs account for 30% of vaccines that are sold in Asia, Africa, some parts of South America. And there is almost a $75 billion revenue in the last from 2010 in the US. And particularly Pfizer has lost a lot of money to in their drug that they created for treating erectile dysfunction, and that was Viagra. One of the things that happened very interestingly by the very famous fashion brand called Diesel. Now, Diesel realized that a lot of their fakes were selling like hotcakes. So Diesel employed a street artist in Los Angeles and asked him to design fakes for Diesel. You look at the contradiction over here. So Diesel is an original, fashion designer. They are hiring a street artist. And what's the role and responsibility of the street artist? To design fakes. And then Diesel sold those fakes at a hugely successful, price and as a venture. So when I say Diesel is hiring people to make fakes, or Louis Vuitton is hiring to make fakes, what it means is they are changing their product from the high-priced a very what you call exclusive range to what we call as a street look finish. Something that looks like just has been copied from Diesel. So these are some interesting design thinking examples that are coming out in the marketplace and is worth considering how to do it. So the last line that I've written is something that all of you should keep in mind, that the counterfeit global industry is USD 1.2 plus trillion. All right. So what a huge market it's there. I always tell, when I'm teaching this, I always tell my students that all the famous brands would not have been so famous were it not for Fashion Street and Linking Road in Mumbai. That's where we get to see the copycat products, and they are being sold so successfully. The question that arises is it wrong to copy? I'm not going to answer it. And you're going to give me, of course, you would say, of course, it is wrong to copy. Then the question that emerges is, why are they not stopped? Are we trying to say that countries cannot stop a fake market? You go to many of these countries in the world, especially in Southeast Asia, including a very developed nation like Japan, and you will find very robust, very thriving, very active counterfeit markets. So, what is it that is making countries in the world? I'm now going to use another word to say encourage these markets when they could be shut down. As I said, technically, we all know the answer. Is copying correct? And the answer is no, of course not. Because when you are copying, you are denying an original creator of his or her rightful share or entitlement to the money that has come to another. But there is a flip side to it. And that flip side is what I have talked about. However, we are seeing, especially with pharma and the drug market, is that there is rampant unfair trade practices. There is piracy in the film industry. There is fraud. And last but not the least, there is free riding. Free riding, we mean that somebody rides on the idea of another creator and takes away the entire credit for the same. So if you look at it, there have been so many instances where in films, somebody has ridden on the script of another person. So there's a lot of theft and stealing in the media and entertainment sector. In the software sector, we find it happening all the time. So therefore, the realization dawned that there have to be stricter boundaries created in the marketplace where this kind of free riding and piracy would be put to an end. Having said that, it's there, it's been successful, but we definitely cannot say that things have come to a stop. Things still continue, and it's like this: the thief is always one with a very clever mind and finds loopholes and ways and means of committing the theft. But the intellectual property laws have been a dampener and have been able to bring down the instances of theft that we are normally seeing. So we come to the constitution of intellectual property. So what are the sort of wheels that we see in intellectual property? The first is the creation, the ideation, the intellectual activity, which is resulting in an outcome. And what is that outcome? The outcome is the asset, the one that you are going to call property. Now, again, I don't want to dwell too much on it, but just to explain a legal concept, all assets are not properties. Assets are that which are advantages to you. All right? But to say that it is my property, it means I should be able to prove legal titles and ownership. So, asset that is created is intangible, asset can be owned, asset is valuable and can be transferred. This transferability of the asset is very critical because it is in this transfer of the asset that commerce lies. Now, you must understand this. Should governments encourage commerce? Is it a good thing for a country? This is a no-brainer. Everybody knows that it is, of course, a very, very good thing, because if there is no commerce, there is no market, there is no money in the marketplace. So the more commerce that you have, it is a greater good news for the government. So government is always trying to do its best to encourage more commerce and therefore to create more assets and therefore create more properties. So the first is, again, I repeat, the intellectual ideation. Then we come to the creation of the asset. And then we come to the emanating rights out of the asset. What I'm trying to say in short is intellectual property is different from the intellectual property rights. So once you have created the asset, you will be getting an entire set of rights that is available to all the owners of those rights. So as you can see, I have done 5. This is not an exhaustive representation of intellectual property. There are more, but these are considered to be the main intellectual properties. The first one over here is copyright. Then we come to patents. Then we come to trademarks. Then we come to designs. And then we come to geographical indications. There are also others, one of which I'm going to mention to you, and that is trade secrets. All right. So what are patents? This is considered to be the most complex of intellectual properties. In fact, it is considered to be the most complex of laws. Very, very complex. This is considered as a technology law, and it has lots and lots of aspects to it, which all very procedural and has to be remembered in the application of the law. We come to copyright. This is the goddess of media and entertainment industry, except that she is treated quite badly and is not given her due share of respect. This is the most common and widely used intellectual property, and these are trademarks, which are signs and symbols which form a trader's identity in the marketplace. They are visual in nature. We come to designs. Designs are those intellectual properties which protect the external appearance of a good. So there's a design and there is a color combination. So this is the design, the squares, this is the design of the intellectual property, the aesthetic look and feel, which is relating to the shape of the goods, which is protected in designs. So I've just given you a snapshot of the kind of intellectual properties that are there. We generally call them statutory intellectual properties for which there is a clear-cut defined law, and those intellectual properties for which I would put it this way, they are recognized, but there is no defined law, particular law for them. All right. So you have to, if in case of a problem, you have to appeal to the courts of law to recognize your view of that intellectual property. Okay. So what are the statutory IPs? Statutory IPs are patents, copyrights, trademarks, industrial designs, geographical indications, plant varieties, which I have not taken, semiconductors, which I have not taken, and biodiversities, which I have not taken. Whole lot of unregistered IP. It could be confidential information. It could be your what you call as trade secrets. It could be a trade dress. It could be your client list. So a lot of things which go under the umbrella of common law IPs. So this is giving you the various acts that govern the statutory intellectual properties, and these acts are those that have been enacted in India. So we are a very, very intellectual property compliant nation. And a lot of times you see in the media that we need to haul our IP laws, etc. Please don't believe that. Our IP laws are quite strong and very good. And we are doing as well as other countries in the world with respect to intellectual property. Coming to intellectual property rights. Now, intellectual property rights is basically an umbrella term. So it means what are the privileges, advantages available to an owner of the right. Two things. The rights are always legally protected. The rights are creating legal boundaries of your function as an owner of the right. So, for example, with respect to your immovable property, your house, your land, do we not write outside on the board very clearly, trespassers will be prosecuted? That same principle applies here. It's your intellectual property. And like, for example, I gave you the example of Covishield. Now, in India, Covishield has been licensed only to Serum Institute. Now, if suddenly another company comes forward and says, hey, forget Serum Institute, we are manufacturing Covishield, will you buy that vaccine? Come on. Tell me. We all know Covishield is being manufactured in India by Serum Institute. Now let's say Bharat Biotech says, just forget it. We can also manufacture this vaccine and we are also producing it. So you will have more vaccines in the marketplace. What do you mean by if it is sublicensed? Yes, Tani, what would you mean by saying it is sub-licensed?
There is a notification by Serum that some other company has the rights, if in case. So just to trust on that vaccine, maybe.
I like that word you used, not the sub-license, but the word that you used now. What is the word you used now? You used the word trust. And that happens with all our drugs. Every time we buy a drug, we want to check the source of that drug. We feel comfortable only when we know the source. Now, let's say I have given you the name of a famous company. I have not given you the name of, a non-entity, as we say. I have given you the name of Bharat Biotech, which is actually the manufacturer of the other vaccine in India, which is Covaxin. But even after coming from a good stable, as we say, are we going to blindly buy Bharat Biotech's Covishield? And the answer is no. Because you are always going to wonder whether Bharat Biotech, stuck to the norms of producing Covaxin. So that is where licensing and sub-licensing comes in, where you want to know that all parameters in the manufacturing have been followed through. All the norms, all the requirements, all the stipulations have been followed through. So that is where the concern comes. So therefore, if somebody is randomly getting up and saying, I'll manufacture, the market won't accept it because there will be problems in quality control. So to ensure quality control, you want to know whether it has been licensed and sub-licensed properly. And coming to the other side of it, if there are market players who are randomly creating drugs or vaccines without taking proper permissions or without taking proper authorizations, then the original creator and the original licensee have the right to stop, to prevent these people from producing or carrying on their nefarious activities. That is very, very important. So when you get IPRs, you get two rights. One are the privileges, that is the right to do what you wish to do with your IPR, to use it, not to use it, to exploit it commercially, just enjoy it, not exploit it, to keep it in cold storage for some time and exploit it later. These are all the privileges and advantages that you have. On the other side, you also have the right. Let's say I'm not using my IPR and somebody else comes out with my IPR. Then do I have the right to stop that person from using my IPR? And the answer is an unequivocal yes. So this is the right to prevent, which is the right to exclude. That is why with IPRs, we always use the word exclusive rights. That is, it belongs to me and me only. All of you are excluded from it. So this exclusion and given this enjoyment is what is intellectual property rights. Having said that, you must also understand another dimension of intellectual property right. If, let's say, Dr. Thomas invents something, and we say that, no, I give Dr. Thomas the right to use this invention indefinitely. Now, as a market practice, is that good? And the answer to that is no. By doing that, I am giving Dr. Thomas an unlimited monopoly. And I think I don't need to educate any of you on the fact that any kind of monopoly destroys the marketplace. So, by their very nature, monopolies are unhealthy. But this was the reason that IPRs are protected, is when people, governments, kings, monarchs all over the world realized that monopolies have to be given. They could be limited monopolies, but they have to be given in order to encourage creativity. So I want an inventor to invent, everybody does not have the same degree of intellectual capabilities. So you understand talent, you understand disposition in a person quite early on in life. And so if you say this person is good in drawing, he must be encouraged to make more paintings. If we say this person has a technical bent of mind and is great at research and inventions, he should be allowed to do that. So this kind of encouragement, where the creators can operate freely in the marketplace without the fear of being copied, was the outcome, or was the creation of intellectual property rights that was devised by all nations together. So nations came to the realization that intellectual property rights must be granted. The word I am now using is granted. They must be granted by whoever is the governing authority, and that monopoly for a certain period of time must be given so that the creator can exclusively enjoy the benefits of his or her creation. This is the background and the objective of intellectual property. All right. I think I have explained it to you, and now I'm going to try to put it in context for you through a very simple jar of coffee. Now, if you look at this jar from top to bottom, everything is kind of, in a fixed item, having a fixed shape, color, etc. All right. So you look at this particular, lid. And immediately when you see the lid, you realize that this lid has a specific shape to it. And it looks good to the eye. So there is an aesthetic appeal to the lid. Look at the jar. How interesting. The jar not only has a shape, it also has a waist. And the reason behind this shape is to enable this glass jar to be held easily. So this particular design that is there, so all this forms part of the aesthetic look and appeal of the jar and is protected by an industrial design registration. This particular thing that you see is a very, very famous, world famous brand, and this brand is Nescafe. This belongs to Nestle, the company, and it is a trademark. Part of the trademark also includes Blend 37. There is an entire copyright that is taken on the entire label that is stuck. So the artistic appeal of the label is taken under copyright. In fact, there is a very interesting line over here. I'm sure you all are not able to read it. And it says, a cup of character. That's a tagline. And that also has been trademarked. Then we come to the granules that are very visibly seen inside the jar, and they are the coffee granules. If you look very carefully, you will notice that these coffee granules are extremely dry and they do have a three-dimensional shape. Now, there has been a particular process that has been applied for these granules, and this particular process is called as freeze drying process and decaffeination. This freeze drying process was earlier patented. So there are patents, trademarks, there are designs, registered and unregistered, and there are copyrights that are there with them, there in that particular bottle. I start with the first kind of, and the first kind of, I'll just take a, I'll just sort of shut out the video for a bit. All right. So we are looking at technology here. And when we are looking at technology, we realize that the people who invent those technologies have various options at their disposal. What are those options? One is, I have created a great technology, but I am a philanthropist. I do not want to commercialize my technology. I want to make it freely available for the world. That's one way of dealing with the technology. Another way of dealing with the technology is no, this is my technology. I don't want to share it with anyone. And I am going to secretly make what I make, and no one will know what I do. There are lots and lots of examples in this world where things have been done in secret and continue to be done in secret. One of the greatest examples of trade secret is Coca-Cola, where the composition of Coca-Cola is kept as a secret to date. Of course, people have reverse engineered it. Of course, people are aware what is used. But whatever is used or what is the formulation of Coca-Cola, the company has not divulged. So there is no patent on the liquid that is manufactured, and it is done as a trade secret. The entire intellectual property on which the company writes, the Coke company writes, is a trade secret. So the formula is a well-kept secret. Then we come to the third method. Third method, and which many people, especially in developing countries like India, do, is they are startups, they are small-time inventors. They do not want to be bothered with expensive intellectual property protections, and they prefer working their invention openly and putting it into the market directly. Their logic is चलने दो जितने दिन चलता है, जितने दिन हम survive कर सकते हैं हम survive करेंगे. The day we get copied, we'll walk out of the market. That's their riding philosophy. And the last, which is the best way to work an invention, is get your invention patented and then bring it out into the market through well-placed legitimate sources. All right. So coming to what is a patent. The word patent means open, on your face. All right. And this word came, these were open documents. So when I say open documents, means it is meant for the public to read. So in a sense, a patent is a public notice. So, in the days of yore, when kings and queens were there, monarchs were ruling the world, they used to have what is known as Raja Ka Farman. They used to come to the marketplace where everybody's there, read out what the king or queen has said. So this became the diktat of the monarch. And these were public notices. And they came to be called as letters patent instead of calling them public notices. Over a period of time, these words have become obsolete, and today we use the word more famously as a public notice. So public notice is issued telling the whole world that a patent has been granted by the state to a certain inventor. So moment I say it like this, it's very clear that there is a grant from the state to an individual, and this grant is a grant of monopoly. That means the individual inventor can use the patent for his or her benefit only. I want you to note over here, when I say inventor, that inventor can be a company also. Is it possible for a company to be an inventor? Who's going to tell me?
Yes, ma'am.
Is it possible for a company to be an inventor?
Yes.
Yes. How many feel it is possible for a company to be an inventor? Okay. Seems like many of you feel that it's possible for a company to be an inventor. But I'm going to disagree with you. Is a company a human being? Company is not a human being. So how can a company be an inventor? But Can the company hire inventors? Answer is yes. So company has inventors as its employee. Company, yes, you're right. Company is a legal person. But despite a company being a legal person, there are lots of things that the company cannot do that a human being does. Can a company sing? No. Can a company dance? No. It's a person, but these are human attributes which the company cannot engage in. Human attributes are very specifically human qualities, human abilities. So a company can hire an inventor, but a company cannot invent by itself. Therefore, the company can take a patent in its name, but company must write down the name of the actual inventor. That is a requirement of the law. Yes, company owns the invention. So there is a difference between owner and inventor. Are you all understanding? This difference we write all the time in the application that we make for any intellectual property. So there is an owner, there is a creator. Most often you will find owners being the creators. But lots of times the owners and creators are two different categories of people, all right, or persons as we choose to call it. So the system of patenting was created by inventors of technology, the system or the monopoly to protect what they have created. I'm not getting into the history. There's a lot of history in the history of patenting. One of the most colorful and brilliant histories of, intellectual property that we can see. But today, over a lot evolution of, say, 500 years, it has come to be that a patent will be granted uniformly by most nations in the world for a period of 20 years. Please don't misinterpret my statement. Patents are granted only by the country of origin. So in India, I will grant Indian patent. In US, we will grant a US patent. There's nothing like a global patent. But can an Indian inventor take a patent in a foreign country? Answer is yes. So international applications are possible in particular or specified countries, but there is nothing like one patent covers all. No. Patent is, and like any other intellectual property, or for that matter, any other law, all laws are territorial. This is one golden rule which we cannot lose sight of. So they are applied only to the territory in which the law has emanated from. So all Indian laws are applicable only in India. I cannot apply a Indian law to US. And a patent is an outcome of Indian law. So in India, I can award a patent. A patent can be granted to an Indian inventor for the period of 20 years. So now, because of WTO, the general understanding is that we should grant a patent for 20 years, and all member nations are following this rule. So this status enables a person to sell his invention, to license his invention, to surrender his invention if he feels, to donate his invention. A lot of US companies have donated their inventions to universities to carry on research as well as exploit the invention. On the negative side, we therefore exclude anybody from using that invention. So the short points about patenting is patent is granted by the government. Here it is the Controller General who grants the patent to an inventor or his assignee. Now, suppose there is an inventor suppose I am working in Pfizer and I have invented the medicine. Then I am assigning my patent. I am supposed to get the patent, but instead of me getting the patent, I am assigning my patent to the company with which I am employed, because the company assisted me in making that invention. For an invention for a limited period of 20 years, which is valid only within the country of grant. All right. I want to keep this short because patent is an extremely technical subject, and it may be very not so easy to grasp the nuances of the law. But the basic patent law revolves around this word invention. The subject matter of any patent has to be an invention only. It cannot be an expression, it cannot be any other thing but an invention. So, therefore, the Indian Patent Act, like other patent acts all over the world, makes it a point to define what is an invention. So, I have given over here what is an invention. Basically, it means a new product or process involving an inventive step and capable of industrial application. So, first thing that we decide in our country is whether that invention that you are calling an invention, whether it is an invention in the eyes of the law. We come to point number two, whether the invention you are calling an invention is a patentable invention or not. So, the first aspect is whether it is an invention or not. So, I will take you to the next slide. Now, these are all examples of things which are not an invention. You may call it an invention. So, for example, inventions that are frivolous, mere discoveries, or formulations of other existing substances. So these are, what we call or scientific principles or formulas. These are formulae, as we say. These are not examples of inventions. All right. There is one particular section which has given a lot of problem to India, and this is this particular section, which is talking about mere discovery of a new form or a new property or a new use of a known substance is not considered an invention. Mixing two items and making an admixture and calling that an invention is not an invention. Arrangement, rearrangement, or duplication of known devices is not an invention. Methods of agriculture and horticulture denying widespread benefit is not an invention. Now we come to non-patentable inventions. They are we are saying over here. They may be inventions, but they are definitely not patentable. All right. Any medicinal, surgical, diagnostic methods, they are not patentable. Mere scheme or rule or method of of playing cards, etc., or forming mental games are not patentable. Topographies of integrated circuits are not patentable. Inventions which affect or are made from traditional knowledge are not patentable. So, coming back, therefore, to get a patent, we need to prove first and foremost that your invention is novel, the first of its kind in the world. While you may be seeking a patent in India, but we have to search global databases and prove that there is nothing anywhere in the world which can qualify as my invention. So it has to be a new and novel invention. The next most important thing about a patent, the heart and soul of a patent, is the inventive step. The inventive step is to show the technological advance, the technical advance that is there in the invention. Otherwise, I'm same as existing inventions. What I have done better than existing inventions to say that I deserve to get a patent. That's what we must show. And last but not the least, we must show that it is capable of being useful to mankind, and therefore it should be possible to make this invention. It should be possible to produce this invention. So industrial applicability and utility is a very, very important feature of patenting. All right. I'm coming to the other intellectual properties, and I'm beginning with one of the history making television serial, and that was Game of Thrones. Just to show you the kind of intellectual properties that are there in the media and entertainment sector. Instead of trying to explain, what I'm going to do is I'm just going to read out to you the provisions over here, just so that it goes into your head as to the the magnitude of things that were involved in the Game of Thrones. I'm sure all of you must have heard about Game of Thrones. I've chosen this particular thing. In fact, I have done a paper on Game of Thrones just to tell you that this was the most watched TV show in the world. And what was it that was making this TV show most watched? Again, the answer to that is very simple. It was most watched because it had a great storyline. And because it had a great storyline, people were riveted to their TV screens and wanted more of it. Now, who should get the credit for the TV show? Obviously, the producers of the television show. And in this case, it was HBO. But more interestingly, from where did HBO get this story? They got the story from an author called George R.R. Martin, who was, he's no longer associated with the universities, but he was a literateur and he was a professor of literature. He was associated with a certain university in the US, and he was a story writer. So he had many books to his credit, but his book called Song of Fire and Ice became very famous. And suddenly HBO realized that here is a fiction writer who is pulling crowds. So if you're pulling crowds through books, imagine how much crowd you will pull through a television show. Rest is history. The producers got in touch with him. And I want all of you to concentrate on this particular line that I have written over here. That is, Martin sold TV rights of his book to HBO in 2007. The first episode was aired in 2011. All right? Now the question is, what do we mean by sold TV rights of his book? Can anyone tell me? Anyone? Sorry, Stani, I missed your question. What about AI coming up with an invention? I'll take your question at the end, but yes, it's a very interesting question. And yes, we are having lots and lots of issues with AI. All right. But I'll take up this question at the end. So tell me, who can tell me what do we mean by saying sold TV rights of his book to HBO? Can anyone tell me? So that they can publish that on their channel. Publish in what way? Publish how? Like in the book that it has been written in print? No. So here is the interesting thing. There was something that has been written in print. And that something now needed to, yes, in a cinematic manner, needed to be adapted and changed for projection on television. So this was the interesting thing. But the fact remained that the concept, the story was his, and he needed to be given credit for his story. What George R.R. Martin did was he wrote. So that is in print. He wrote the story. But the story is then forming the basis for the cinematic expression. The expression is now cinematic. The medium has changed from book to television, but the author must be given credit. So therefore, he sold the TV rights of his book to HBO. Rest is all basically the fantastic figures that we are seeing as far as this Game of Thrones go. It went on to make 73 episodes, 47 Emmy Awards, glorious seasons. The last was the most watched season. The final episode aired in 2009 and it had garnered a record 17.8 million viewers. What was interesting is that HBO invested a total of 1.46 billion USD in the making of GOT, but harvested twice that. So just imagine how much it earned. And for all of you, I need to mention this because this kind of model is quite unique to India. HBO has no advertising revenue. HBO is a subscription model. So they are getting all their revenues from subscribers. And therein lies the problem. There were lots and lots and lots and lots of people in the world who did not subscribe to HBO. They yet watched Game of Thrones. So obviously they watched bootlegged copies or pirated copies of Game of Thrones. To watch the actual episode, I have to subscribe to HBO. So this is the unfair trade practices that go on in the world. Nonetheless, it became so famous, so popular. Each of the names became so popular that a whole list of baby names, you can just Google it, on HBO baby names came out. So we had directories of baby names. Somebody wanted to name their daughter Arya, or somebody wanted to name their son Valor, whatever. So various names. So you see, this is where the intellectual property of R.R. Martin lies, in the names, in the characterizations, in giving them a particular script. This was the IP of R.R. Martin. So funnily, lots of alcoholic beverages came out under the Game of Thrones names. So they then realized the potential of the intellectual property created, and HBO has, for your information, more than 100 registered trademarks and 100 more applications filed. Everything was selling. Every name that is used was selling. So this is a snapshot of what George R.R. Martin earned and what HBO earned. So in 2006, Martin earned 10 million from publication, 15 million from HBO series. 2015, he earned 19.5 million from Song of Fire and Ice. And in 2013, he got something like 1.3 million. So I have taken it from 13 to up to 2016. Likewise, you see the income of HBO from seasons 1 to 8, they made 3.12 billion. From CD sales, 168 million. From merchandise, 132 billion. So all of this is added to 3.12. So it was brilliant in the kind of money that HBO made from a series like, Game of Thrones, right? So these are some of the, like for example, let's take a famous, shall I say, a famous T-shirt manufacturer, a branded T-shirt manufacturer. And branded T-shirt manufacturer wants to ride on the HBO wave of Game of Thrones. So they come out with a T-shirt which says, "Winter is coming." Now, can they use the word "winter is coming"? Answer is no. They cannot use the word "winter is coming" because the word "winter is coming" has already been appropriated by HBO as their trademark. So to use "winter is coming," that famous T-shirt company has to go to HBO and says, "Please license me this particular trademark. I want to use," let's say Calvin Klein says that. So I want to use "winter is coming." So they are Calvin Klein T-shirts which are using a particular name or a tagline from another company. So this is how, interestingly, intellectual property market has developed all over the world. So T-shirts, whiskeys, bottles of tequila, all of them have taken names from the Game of Thrones. Interestingly, what emerged also was how Iceland, not a very popular country, Croatia, not a very popular country, and Ireland, not a very popular country, suddenly emerged as the tourist destinations of the world simply because Game of Thrones was shot in these locales. All right. So this is something that I have written for all of you. Coming to trademarks. What are trademarks? As I already mentioned to you, they are visual signs and symbols that a trader uses to mark his presence in the marketplace. He uses those signs and symbols to be identified with. All right. So he's saying that I'm using the name, let's say, I'm using the name Nike. That's my symbol. You should identify me with the word Nike. Now, Nike is a Greek goddess. So, but I'm using the name Nike for footwear. So, whenever you see footwear, think of Nike. That's me. That's my presence. So, you have created an identity built around a name. That name which is visible to the entire marketplace. Over a period of time, people got very, very involved in designing the names. So there used to be complicated art around a name. The more the design, and it all became one big symbol, which we generally tend to refer to as a logo. So logo has a background, a color combination, a scheme, a design, and in that would be the trader's identity in the name that is used. So various combinations, permutations possible in designing trademarks. What you need to know that a trademark means any device, brand, heading, label, ticket, name, signature, word, letter, numerals, shape of good, their packaging, or any combination thereof. All right. Basically, trademark is the longest living IP because a trademark is granted for a period of 10 years, renewable after each such period. So once the tenure is over, you can again ask for renewal of the trademark. Moral of the story is if your trademark has not done well or you have not done well as a trader, then you may abandon the trademark. All right. So I have taken some of the trademarks for you to have a look at it. I like ICICI trademark very much because it is showing you a human being, an ICICI. So it's all about I, and so well designed it is. McDonald's, again, a great trademark. It's French fry over a paper basket meant to attract kids. Nike has the world famous trademark, which is called as a swoosh. This particular tick identifies with speed. So you're saying that, with the Nike shoes, you can run faster. One of the best trademarks in the world is Kodak. What a beautiful name. No meaning at all. It means nothing. So some of the best trademarks in the world are those which are arbitrary and mean nothing. They are coined words, they mean nothing. So begins with a hard consonant like K, ends with a hard consonant like K. So what happens is, if you try to copy this word, you'll find it very difficult to copy this word. The closest that you are going to come to copying this word is to say it is Kodak. And the moment you use the word Kodak, everyone will know that this is a kind of a copy of Kodak. So there is always going to be a threat of infringement of having copied Kodak. So these are some of the great trademarks that we can see. The function of a trademark is not only to identify the trader and the product of the trader, but the main function of the trademark is to distinguish two competitors. So they are traders in the same category of goods, and you are trying to distinguish them. Therefore, Nike's competitor Reebok, and if I'm looking at Nike, Adidas, Reebok, they are all in the same bracket, but each one's name is so unique. So you know that a Nike is not the same as an Adidas or is not the same as a Reebok, all right? So these are some of the things. Today, of course, that is what branding is all about. A trademark becomes so famous that you are watching out for the trademark to buy your goods, right? You say it's a Hindustan Unilever product, it's a Tata product, or it's a Godrej product. So this is like an umbrella, a canopy on all products that are coming out, which individually would have, again, a different. So suppose I look at Hindustan Unilever, then I say Lux is a particular brand within the Hindustan Unilever. So trademarks upon trademarks. So today the trend is that each company would be owning thousands of various trademarks depending upon the success of the company in the marketplace. So fundamentally, trademark guarantees and and assures a certain quality of products. All right, we come to how the trademarks are functioning. All right, so when I'm looking at a trademark and how do I understand its value, so you look at how unique the trademark is, right? Now, remember something, when I do a lot of trademark registration, so when we are registering a trademark, the registrar of trademarks sends back a trademark saying that it has no distinctive feature. That means your trademark sounds as good as another trademark in the marketplace, and we are not able to understand how is this trademark different from existing trademarks. So remember, the more unique the trademark, the more distinctive is that trademark. So we have to concentrate on the distinctiveness of a trademark. As I said, look at the word Kodak, look at the word Caltex, look at the word Apple for computers, look at the word mango for clothing. Great, brilliant trademarks have no parallel. So that is what you are trying to do. You want to build a brand, so you have to try and create public retention and recall to create that particular brand. All right. So basically, when we are choosing a trademark, a lot of intellectual property goes into choosing that particular trademark. So it has to be done in a well thought out manner. Randomly don't pick up any trademark and cannot make it into a good brand. Now, for example, I've given you a picture of Toblerone. The name is Toblerone, very unique name for a chocolate. Very, very distinctive name for a chocolate. But over a period of time, what they realized is the shape of this chocolate had also become its trademark. So the word is a trademark. The shape of this chocolate is also its trademark. So you can take shapes of items to be their trademark. All right. So this is to show you that how you leverage your mark is your business. Now look at this. This horrible electrifying purple. But this was not meant to attract you per se, but rather to attract children. And in this, Cadbury strategized very successfully. So last 20, 24 years, Cadbury has taken a trademark on this Pantone color. It's a Pantone with a particular number, and this is that electrifying purple. Now, what has Cadbury done? Cadbury's IP, intellectual property, lies in this color packaging that it has used. This color packaging is called trade dress. So whatever Cadbury items you will see on the shelves of a marketplace, you will see that they are all in this color purple. All right. So this has become not only Cadbury's trademark, but it has also become Cadbury's trade dress. Likewise, you can find a parallel in Apple. Apple is for computers, laptops, phones, etc. But Apple trade dress is white. So you'll have Apple stores designed in white, Apple logo designed in white. That's their trade dress. So that's there's a trademark as well as a trade dress. Now we come to showing you the fakes in the marketplace. These are, how trademarks are being abused. So you have shoes, they are a famous manufacturer. You have Nikes and then you have Hikey. I mean, you are most likely to miss the word H. Not likely to happen. Look at this. We have seen bottles in Europe where we were shown in a particular class how the infringement is taking place. And they kept two bottles. One was Coca-Cola and the other was Cola-Coca. And they kept asking the entire class, what's wrong? What's wrong? And believe it or not, but none of the students in the class could identify what was wrong. All of us are saying Coca-Cola. We are saying one bottle is Coca-Cola, the other bottle is also Coca-Cola. Till after some time, till our eyes got adjusted, till we realize that, oh, okay, the one of them is not Coca-Cola, but is Cola-Coca. You know, so these are some of the ways that the counterfeiter works. The counterfeiter rides on the name and thinks of ways and means to make the counterfeit product look identical to the original product. You will find one of these areas where I found a lot of abuses was in these chips. What is that famous wafer company where the chips were marketed in a in a similar way, and people only saw the green color of that chip and the chip manufacturers, and they bought the chip without realizing that it's of a different company. We come to another story, and this is a story which is a very commonplace story. Everyone takes it for granted. No one thinks twice about the name Harry Potter. Are Harry and Potter, so what is there special about the name? But millions have been riding on this particular name. This particular book, the author has become one of the world's top billionaires now, and she is J.K. Rowling. And what she succeeded in through making her books, no other author has been able to do this far. So it's brilliant in terms of her success story. She was just a very average, ordinary woman who was trying to make ends meet. This was a story, was a single mom looking after her child, and she just didn't know what to do to create. She was essentially a journalist, and she knew that the only thing she could do was write. And then while telling stories to her daughter, she struck upon this gold. And this gold was in the form of the fictitious character that she created, Harry Potter. Such a relatable name, such a relatable. So in therein lies, in the simplicity lies the intellectual property of Harry Potter. And she created these fantastic tales. The last one that she created history in terms of the sales of that book. In UK itself, 2.6 million of the books were sold in 24 hours. 2.6 million books in 24 hours, unheard of. All right. Now, just to give you some of the statistics, just like George R.R. Martin, Rowling's first 6 books sold over 325 million copies. So many films made from her books. 5 Hollywood adaptations. When you're reading 5 Hollywood adaptations, what I have not written over here is the number of language adaptations that have happened of her books throughout the world. Her books have been made into movies in various languages in the world. So just not the 5 adaptations that I have talked about. The first Hollywood adaptation ranked 4th in the world of highest grossers. Music soundtracks sold over 1.1 million copies. Merchandising rights, which has gone to Warner Brothers. So there were so many things that this particular thing, this Harry Potter created. So, and what I have written in this particular slide is most important for you all to understand how transformative intellectual property can be. Intellectual property has created rags to riches story. You have the FB creators, Facebook creators. You see what they have. It's a rags to riches story in terms. What is Bill Gates? At the end of the day, nothing but a successful tale of management of his intellectual property, Microsoft, Windows, all of that. What is Apple? Steve Jobs. What did Steve Jobs create? Nothing but successful intellectual property. So it's always very, very transformative in the way lives are changed in the good and proper management of intellectual property. So what I wanted to say in this slide was there's this one single lady who's the author of this fantastic tale called Harry Potter. And she wove a world of fantasy. The world of fantasy which appealed not only to children, but also to adults. And through that wonderful fantasy or fantastic tales, so so many people got their bread and butter, so many livelihoods were established, so many success stories were built. So there were publishers who made money, there were editors who made money, translators, printers, marketeers who produced different language versions of the book as well as the movies. So producer, actors, directors, music composers, all of them became so famous. And then there were the digital transformations in terms of designers and software developers, etc. Most interesting has been the toys and the merchandise that have come out from Harry Potter. You know, you have the flying frisbees, and then you have those jumping frogs. So many different toys, sweets, chocolates that have come out of Harry Potter. Entire industries have got set up from the Harry Potter storybooks. So multiple industries and livelihoods for hundreds as well as for free riders. So wherever Harry Potter has been shot has become a local or a locale for, you know, tourism. So people get carried away and say, oh, okay, Harry Potter was shot here. So there are some places in New Zealand where people go to see where exactly Harry Potter has been shot. So coming to what protected Harry Potter. So what protected Harry Potter was nothing other than copyrights. So copyrights is literally the right to copy, not other people's work, but the right to copy your own work. Nobody else should be given that right. You are the producer of the expression. You have, whether you've created a book, whether you've created a poem, whether you've created certain dance steps, whether you've created a drawing, a painting, you have created a work of architecture, a work of sculpture, you are the creator. It's your expression, and therefore you alone should be given the right to copy that expression. So therefore, I must not only be given the right to reproduce what I have done, but I should be given the right to reproduce it in any other format that I wish. I hope now you can understand what I meant when I said George R.R. Martin sold the TV rights of his book. So there is a book, and then there are adaptation rights. And those adaptation rights are also part of the copyrights of the original author or producer of the expression. All right? So you have the right to make prints, reprints, and republish the original works. And therefore, you have the right to control how further reproduction and distribution of your work should take place. All right? So copyright law came to this world as one of the last intellectual properties. It's one of the very recent intellectual properties because it came with the advent of the printing press. Till then, writing was not popular. Writing became popular only with the advent of the printing press, and people learned to reproduce what they have written. So I make 10 copies, and then somebody demands more of it, so I make more 20 copies, and then somebody demands 100, so I make 100 more copies. So this was possible because of the printing press. So with the printing press invention came in copyrights. And so copyrights is the youngest of the children in the basket of intellectual property rights. And it has changed forever the aspects of the media and entertainment industry. So fundamentally, it gives you the reproductive rights, the right to copy, print, distribute, adaptive rights to make modified versions of the original work. It has also the right to distribute copies. It also gives you the right to perform the work. So these are performance rights, which generally go to the actors and the actresses. Then you have the display rights to exhibit the work. Attribution rights means the right to claim ownership and authorship of the work. Rest, I am not getting into it because it will become a little complicated. So I will leave it, but you can see the slide. I've written economic rights and I've written moral rights. Moral rights is a great discussion. Just to tell you in short, that even if you have sold your work, you tend to hold on to the moral rights over the work. So nobody can destroy your work, even if they have bought your work. Suppose I say you've written a book, I buy the book and I destroy, burn all the copies of the book in the marketplace. I have no right to do that. So you can take an action against me, even though you no longer officially hold copyright in the works. So where does copyright subsist? Copyright exists in all original literary written works, in all dramatic and choreographic works, in all musical and artistic works, in all cinematographic films and multimedia products, in all sound recordings, in all computer programs, algorithms, tables, and database. Remember one thing, copyright does not protect ideas. Copyright protects only the expressions of the ideas. All right. So no protection of ideas per se. The expression of the idea has to be protected. So what copyrights protects is the originality of the expression. What copyright is therefore trying to say is, and this is something that going forward you ought to remember any which way, is that people can get the same idea at the same time. There's nothing impossible about it. Like, for example, today, if I'm looking again, I'm coming back to the COVID example. Because of the pandemic, there are so many companies in the world who are all working towards the vaccine. And since they are all, pharmacists or pharmacologists or whatever you choose to call them, they are working in the same direction. So people get the same idea at the same time, and there's nothing wrong with it. What we are saying in copyrights is the expression of the ideas. We're not protecting your idea. Ideas are being protected by patents and trade secrets. Here, ideas are being protected only through their expression. So you cannot copyright your idea or your fact, but you can only copyright the form or the arrangement or the expression in which that idea has been conveyed. Okay? Just to give you an example. So let's say a very famous line is, Jack and Jill went up the hill to fetch a pail of water. All right? Now this can be conveyed in another way also. A little boy called Jack went with his little sister called Jill up a hill to get a pail of water. I have said it differently. Or they went to a well up the hill to collect water. So we are saying the same thing in a different way. Now, since I have said it differently, I should be given a copyright on what I have said, and you should be given copyright for Jack and Jill went up the hill. That's what we are saying. But if I am saying Jack and Jill went up the hill, there was a well there to fetch a pail of water, then I am basically taking your lines and putting in one additional line of my own. That, that is stealing of ideas. And that has to be discouraged. So basically, we are saying that when we copy, we can say the same thing, but we have to say it differently. The essence may be the same, but it has to be said differently. Now, for example, you find a lot of copying happening in the area of doctoral research. What people tend to do is cut, copy, paste. And that's what we are saying is not permissible. You may take the essence of what another has written, but you have to put that in your own words. So copyright is only in the form, the arrangement, and the expression. As an extension of what I have just said, is also something for you to remember. There can be no copyright in facts. There can be no copyright in news. Copyright will exist only in the views of people. So opinions are copyrighted because I'm expressing my opinion in my own way. But to say so many people died out of COVID at so and so time, that's news. That's a fact. There's no copyright in that statement. All right. So in this particular slide, I have taken the issue of ownership. As I said, who are the owners of copyright? Copyright is extremely valuable. A lot of money rides on copyright because copyright is transferable. So if I own the copyright in a particular book, in a particular film, in a particular transcript, then I transfer the copyright in that to another person, another place. So just imagine going back to J.K. Rowling. She wrote the book. She transferred the rights in her book to her publisher. Her publishers then transferred the rights in the book to different publishers all over the world, not only in English, but in different languages. So, multiple levels of transfer of copyrights took place in one book called Harry Potter. And let's say Harry Potter and the Sorcerer's Stone, or Harry Potter and so and so. So, this is the way you've got to understand. So, despite being so famous, so important in the world, she has been battling a lot of intellectual property rights battle. A particular publishing company in Chengdu came out with pirated versions of Harry Potter so that multiple publications could come out. So, like, she is coming out with Harry Potter sequels at her own speed. But this Chengdu publishers, they wanted to capitalize on the success and the name of Harry Potter. So they put some authors to work who captured whatever she was writing in her style and came out with, multiple books on Harry Potter till people read it inside and realized that this cannot be J.K. Rowling's work. Same thing happened in Russia. Russia came out with a series called Tanya Grotter series, where the hero of the book was a young girl. But the picture of that girl was made to look like, Daniel Radcliffe's face on the book. So the girl looked like a boy, except that he had two plaits down. So, when counterfeiting takes place, when piracy takes place, people use their head to do all kinds of things to copy and give the impression that it is the original. When this last particular book of hers came out, a young girl in Paris sat through the whole night and she typed the 700 odd pages of Harry Potter and Sorcerer's Stone through the night so that her friends, and spread it on the internet, so that her friends who would not be able to buy the book could read it. Now, this again is an infringement of copyright. And the magistrate who hauled up the girl, she's 17 years, realized that this girl did it with an attitude of nobleness rather than to deprive JKR or the publishers of their market. It was done so that people could access the work more easily. But they left her off with a warning saying that this amounts to copyright infringement. So the publishers sued. So you must realize who has the right to sue, who has the right to stop an incorrect or unfair transfer. And that is the owner of the copyright. Author, of course, but owner of the copyright. So we need to distinguish between ownership and author. So authorship is obviously the one who has first created the work of whatever it is, whether it is work of letters or work of art or work of music or work of cinematographic film. That author has to be acknowledged. The author then gives it to his or her employer, who will become the owner of the work. So employers of work, they are also the owners of copyright. Webmasters, creators of web page, when they are commissioned, they are the owners of the work. Licensees of the creator and the author who is licensed to use the work may become the owner of the work. And in all cases where company is the employer, they become the owner of the work. So this is an important concept that needed to be understood. However, with copyrights, the most important concept that needs to be, especially for most of you coming from the area of research, that is the concept of fair use. Now, there is a very important concept here. And the concept is what I mentioned in the beginning. Were it not for copying, we as a human race would not have progressed. Now, what the law is saying that, if you copy 2 words here and 2 words there, it is not really what we call as substantial copying. It is not what we call as copying so much that it damages what you have created. So that's why we say law does not care for trifling matters. So by bringing in the doctrine of fair use, the US courts brought in a concept which allowed science, technology, research, and development to progress through fair use. For example, all of you know that a big part of your research are the use of citations. What are you doing in citations? In citations, you are quoting somebody else's work, but you are giving credit for that person. By citing, you are using a legal method of referring and using another person's copyrighted work. That is the method of citation. But do you need to cite? Answer is yes, you need to cite, because unless and until you cite, you're not able to make your point. So to make a valid point, it is important for you to cite other people's work. Now, this should not be taken as infringement of copyright, but this should be taken as fair use. Now, coming to another example. Let's say a very important Van Gogh painting is stolen from Louvre. Now, when the reporters, not only in Paris, but all over the world, are referring to this particular incident, they will have to explain to the world who Van Gogh is and what are his paintings and what are the various paintings priced at. So they will have to show snapshots of the various paintings. Now, while doing and showing the snapshots of the various paintings, can we say that they are infringing the copyrights of Van Gogh paintings or whoever owns those copyrights today? Answer is no. It was necessary to make a particular point. So there is what we say for criticism, for review, for research, to report current events. This Van Gogh example is reporting current events. Sometimes it becomes necessary to copy an original work and bring it into public domain. There is no intention to harm or deprive the original owner or the creator of the work. So, for example, there's a very famous case called Sega versus Accolade. All of you know about this gaming company called Sega. Now, Sega sued another gaming company called Accolade. And what did Accolade do? Accolade copied the console, the gaming console that Sega used for a particular game. Now, why did it copy that console? It copied that console, as it told the court, to reverse engineer and find out what were the components that Sega had used in their console so that they do not end up having any identical element in their console. See issues that come up in the marketplace. And therefore, say Accolade was able to convince the courts that it had reverse engineered the Sega console in fair use and that there was no intention to infringe the copyright of the famous gaming company. However, one important element that has to be understood by all of you, often we tend to treat all of this in a very casual manner. And I want to say at this point, you may end up thinking that you have not copied. But whether you have copied or not, or whether or not you are guilty of infringement, is for the courts of law to decide. All right? So the courts of law generally use 4 yardsticks to decide whether any expression has been copied in fair use. Number 1, they decide what has been the purpose of use. Why did that person copy? So, for example, the Van Gogh painting, or for example, the Sega, they copied it for a particular use, to report a current event or to ensure that they don't infringe. That was the purpose of the use. What was the nature of the copyright? Was it an algorithm? Was it a printed matter? Was it an artistic expression? it depends upon, like, for example, if an algorithm is copied, the entire technology is lost. So one has to be completely, mindful of what one is copied. If I copy even a portion of the algorithm, that algorithm becomes useless because it's gone out into the public domain. How much have I copied? Have I copied so much that it is going to harm someone? Now, this how much have I copied is one of the most complex questions. Sometimes copying 2 lines also can create immense harm. Sometimes copying 2 pages also is not substantial. So this has to be decided individually by the courts of law by going into the merits of the case. Now I'm going to try and wind up quickly. I am coming to the last few portions that I need to take. Industrial designs. You can see I have given many examples, and mostly they are examples to do with shapes. Mostly they are examples to do with the aesthetic look and feel of a particular product that is used in the marketplace. Today you will find that so much goes into shoe designing. The heel, the sole, the upper, like for example this chair. Look at the, we call them ergonomic furnitures. So cars, there's an entire industry on how to design cars. There's an entire segment today of goods which are known as luxury item goods. Why do people buy Mercs and what is the other one? The Beamers and the Mercs. Why they buy? They buy it only for, or the Audi, they buy it only for their looks. Whatever you may say, I'm buying it for the engine. Finally, at the end of the day, the big buck is spent on how dashing the car looks. All right. So there is a lot that rides on looks. What is fashion industry if not looks? So the looks of the garment is what the entire industry is riding on. The looks of the bags is what the entire industry is riding on. So looks play a very, very important part in development of product and brand in a company. And therefore, the idea of a shape, configuration, pattern, or ornaments or composition of line is very critical to the development of a particular intellectual property, which we call as industrial design. So this particular design that you have given should be capable of industrial production. So therefore, it applies only to an article. It has to be an article of manufacture. This article should be produced by an industrial process. And it is referring only to the external and finished form of the article. It can be a 2-dimensional design, it can be a 3-dimensional design, or a combination of both. But it has to be relating to the external features of that article. Just to emphasize this point, like for example, I am saying, how does a Merc look? Externally, how the Merc appears. We are not asking how the Merc's engine has been made, how the engine is functioning. That is all patented. The functioning is to do with patent. The looks are to be doing, actually industrial designs are a sister to patents. They are complementing patents. So patents look at functionality and industrial designs look at aesthetics and looks. So it should be the appearance of the product on site. It's very, very different from the technical and the functional aspect of the product. All right. Now, what is required for us to get a registration on industrial design? 2 requirements. Now, this is something I'm going to stop and repeat over here for all of you to remember. Patents protect inventions. Those inventions have to be novel, have to have an inventive step, and should be capable of utility to mankind. Only then a patent is granted. Trademarks protect signs, symbols, any visual combination which creates an identity for the trader in the marketplace. All right. The important thing about this identity is that it should be unique and distinctive. It should distinguish between the identities of 2 traders. That is the important thing of trademarks. We come to copyrights. What does copyright protect? Copyright protects only expressions. whatever may be the form of the expressions. So the expression lies in the painting, in the sculpture, in the writing, in the film, in the TV series. These are all matters of expressions. In the music, so all of this, in the poetry and the rhyme that is lying in the poetry. So these are all matters of expression. And therefore, when we are looking at expression, we are only looking at originality of expression. How original is that expression? So when you're reading a copyrighted work, the first thing that should strike your mind is that this work is different from other similar works that I have written. It should not remind you of something that you have read or seen or heard. If it reminds you of something that you have read or seen or heard, that means it is a closed copy. All right. Coming to industrial design. Industrial design, how is it protected? It is protected only if it is novel and if it is original. So novelty aspect taken from patents, originality aspect taken from copyrights. So the two requirements to protect industrial design are novelty and originality. So it should be capable of, I often say this, and it's a funny part, that ugly designs cannot be protected. It should be aesthetically appealing. This is again a very interesting intellectual property. So far, all the intellectual properties that I have talked about are individually owned. This is talking about intellectual property rights belonging to a community of producers. So let's say Kanjivaram weavers, Katputli makers, Bidri workers of Karnataka, again, Chennapatna toys, Bandhani workers, Tanjore paintings. So there are producers, artisans, farmers, Alfonso mangoes, who say that our product is famous because it comes from a particular geography and because of the geographical attributes in that particular product. For example, Alfonso mangoes, one of the best examples that I can give. It doesn't grow everywhere in the world. It grows only in the particular area surrounding Goa, the Ratnagiri district, and the Konkan region of Maharashtra, where the soil, the climate, all contribute to making Alfonso what it is. Same principle is used for French wine, that is champagne. Champagne comes from a very famous district in South France, which is called as the Champagne district. The wines there are spectacular, and they end up lending the very special quality to the sparkling wines that the region produces, which is now famously called as champagne. No other country in the world is allowed to use that word champagne. Likewise, no mango producer of the world is allowed to use the word Alfonso. So these are coming from a particular area, and therefore they are famous because they come from that area. This is Mathura Petha, this is Banarasi Pan, this is Tirupati Laddu, this is Galauti Kebab, this is Sikh Kebab, this is Darjeeling tea, this is the queen of our geographical indications in India, this is Bengal Rasgullas, this is coffee from the south of India, and this is Bikaneri Bhujia. All of them are geographical indications with some geographical attribute to each of them. This particular region, Lucknow, is producing these kebabs because of the mixture of certain spices and tradition that is involved. Here, this is a trade secret. This is Aranmula Kannadi from Kerala, but this story I find most fascinating. Many of you would already be knowing the story of Aranmula Kannadi. Aranmula is a temple, and this was known as the Aranmula Kannadi Pratibimbam. So Pratibimbam is the mirror. Kannadi are the ironsmith or the bronzesmith who were making this particular alloy. They were originally from Tamil Nadu. They sought shelter in a particular kingdom. And the king said, what you can do for us, so you have to prepare some kind of things to dress the deity and the idol there. And then they thought upon a certain alloy. And this alloy is a very, very shiny kind of an alloy. And nobody knows what is the exact composition of this alloy. So interesting is the story that it is a traditional knowledge, because this has been going on for 700 to 800 years. This is also a trade secret, and it is now protecting today 19 families who make this Pratibimbam in Kerala, Aranmula. So very, very interesting stories on all the geographical indications that we have. We have today about 710 geographical indications. What a proud moment for India, because all of these are helping to add to our exports. Exports are increasing in these particular items. So India ends up making money. I am not getting into the entire detail, just to tell you this is what it is. Coming to trade secrets, I have already mentioned to you, very difficult to protect trade secrets. Trade secrets can be protected in the head only. And that is so difficult if we want to trade in my trade secrets. I cannot trade in my trade secrets by keeping the technology only in my head. It has to come out. And it has to come out in the form of sharing the technology with my employees, with my artisans, with my workers, with a licensee. I have to do it. So the technology has to be shared. While we are saying Coca-Cola is a secret formula, the formula has to be shared. Kentucky Fried Chicken is a secret formula, but it has to be shared, because you can't create franchises unless and until you share. But how Kentucky Fried Chicken operates, very interesting. They will not give you to make the spices. They will send the spices to the franchisee outlets. So spices are where the actual mixing or the intellectual property lies. All right. They will tell you the particular quality of the chicken to be used, the dimensions of the bird to be used, etc., etc. But the spiciness and the exact admixture of all that has to components that have to go into making a Kentucky Fried Chicken, some portion of it will still be kept as a trade secret. That's the only way we can protect a trade secret. So a trade secret is basically a technical or non-technical data, a formula, a pattern, a compilation, program, device, method, technique, drawing, process, financial data, list of actual or potential customers or suppliers, that is sufficiently secret to derive economic value, actual or potential, from not being generally known to other persons who can obtain economic value from its disclosure or use. Right? Coming to limits of IPR, I already finished telling you that patents are a monopoly right given for an exclusive period of 20 years, not renewable. Ends there. Finished. Over. Then the invention comes into public domain. Trademarks are for 10 years and renewals possible. So it goes on and on until you are able to renew it. Copyrights in published literary, dramatic, musical, and artistic works. It is given for the lifetime of author plus 60 years. However, copyrights in photographs, cinematographic films, sound recordings are 60 years from the year in which it was published. Broadcast reproduction rights are 25 years from the next calendar year following the year in which the broadcast is made. Performers' right, again, another 25 years. Industrial design is in our country given for 10 years first. You can apply for a renewal for another 5 years. In all, it is given for 15 years. There are lots of other countries like Malaysia, etc., where industrial design is given for 20 years, 22 years, 25 years, depending on the country in which you reside. And trade secrets is only protected by contracts, if at all it has to be protected, and otherwise there is no other method of protecting trade secrets. Coming to the last segment, how do you build your IP? The only way you can build your IP is first recognizing that it is an IP. That only you can do. You have to understand your worth. You have to know the worth of what you have created. Every song cannot become a hit. Every poem cannot become a hit. Every story is not Harry Potter. Every television serial is not Game of Thrones. But Is there some merit in what you've done? Is there some potential in what you've done? Is it worthwhile going the entire route of protecting the intellectual property you have created? So we have to first recognize the asset value in what we have created. Then we can go to create it as a property. All right. First recognize what is the asset value, then create the property. Protecting the IP created by a method of registration through the legal processes given in the various countries is what we should be aiming at. So there are, as I'm saying, not necessary that you must always get it registered. You can still protect your IP through the non-statutory method by not registering it, by protecting it through contracts. We can still do that. But best method would be to seek registration. However, all of this requires a lot of strategy and thinking on your part. You must understand what is the potential of your IP and what can it fetch. Once you understand that, then you can understand how to manage the process. So the processes may be manual, the processes may be automated, but you cannot do process management without evaluating risks. So you must understand the risks at every stage, right from the conception of the IP to the last part when you have developed and commercialized the IP. A lot of risk in commercializing of the IP all the time, but that doesn't stop you from commercializing it. So therefore you protect it first so that the risks during commercialization are minimized. All right. So knowing all of this is very important. Now I come to the value in the innovation. I want to mention to all of you that there is no information that does not have a price tag to it. So every product, every piece of information comes with a price tag to it. Whether it is valuable or not is for the marketplace to determine it. So the product could be your expression, your technology, your marks, etc., etc. But issue is it saleable? There are some products which are so valuable that right from the time one has conceived it, you find a buyer for it. And there are some products which have been conceived, which are captured, which have been put into prototypes, which have been put into production, which have been put into commercialization, but yet is not able to find a proper market for it. So the value of an intellectual property lies in three things. And these are the three sacrosanct things: how the market perceives it, how the public perceives it. So it is all, we always say a movie is a hit or a miss depending on the way the public has seen it. So that's exactly the concept of intellectual property. Next question is, who owns the intellectual property? The owner also makes a huge difference to the commercialization of the intellectual property, because to push an IP, you also require financial backing, a lot of funding. So to whom the IP belongs, who is taking the credit and the cream for the IP, what value the market sets for it, is all very, very important in understanding the value of the intellectual property. Is there a legal system necessary to protect your innovation? It depends whether there is a legal system there or not in the first place. There are lots of countries in the world where there are no copyrights, where there are no patents, or there are countries in the world where everything is kind of mixed. So we have to realize which country we are in and what can be protected within the territory of that country. All right. The whole thing about it is, if there is an intellectual property, and if you have protected that intellectual property wisely and securely, then it becomes not only a fountainhead of knowledge, but it also becomes a spring of cash flow for the company. All right. This is the way intellectual property is being protected in India. They are coming under the Ministry of Commerce and Industry. Under that, we have the Department of Industrial Policy and Promotion, which is famously called as DIP. Under DIP, you have the Office of Controller General of Patents, Trademarks, Designs, Copyrights, Geographical Indications. This is the segregation. This has come in just now, just 2 years ago. Till then, it was being looked after by the HRD ministry. Now everything is under one basket. We also have the Ministry of Communications and IT, which is looking at semiconductor integrated design circuits. And we have Ministry of Agriculture, which is looking at protection of plant varieties and national diversity. The last slide, my concluding slide, is something that I want always to share with everyone, because I find this so brilliant in the way it has been written. It says very simply, to create something from nothing in all the natural world is a uniquely human ability. Using our minds, we originate works of art, generate inventions, accumulate knowledge, and discover truths about the world we live in. What sets the information age apart from prior periods in history is the price tag we put on those intellectual creations. With this, I leave you all with your questions that you may want to ask. So, the first question that has already been asked is about the artificial intelligence and whether you can get a patent and a copyright. So, I do not know, but have you all heard about that human robot called Sophie? And Sophie was granted intellectual property rights, and Sophie was also granted citizenship by UAE. But this raised another debate all over the world, and that is machine inventions. Can we grant them, the status of an inventor? As far as the law is concerned, the law contemplated the inventor to be human. The law contemplated the author to be human. Therefore, the law is of the view today that AIs cannot be granted patents or copyright in themselves. They have to bring in the human element to claim the inventorship or authorship for the work. So I hope I have answered that question of yours. However, companies producing AI are seeking patents and copyrights, at least they are showing inventors and seeking that inventor of the AI is so-and-so, and therefore the human element is brought to that inventor. Any other question?
Yeah, if anybody wants to ask questions, you may either use the chat option or you may unmute and ask. There are no questions in the chat.
Any questions? Anyone? Most welcome.
Ma'am, for the film music,
Yeah.
I mean, there has been problems between music director Ilayaraja and music producers and the singers. Ilayaraja fights with people saying that he needs to be given royalty for the songs which we create, and they are not supposed to sing that in reality shows, or if at all they need to sing, the music director needs to be paid royalty. What is your say on it?
So, at the end of the day, there is something called as performance rights. All right. Now, the question is, if a singer is singing exactly as the song has been rendered in the original, CD or original recording, then there is an issue of copyright violation. However, the law is also taking a generous view and saying at the end of the day, the song being rendered is by an individual artist. And so there is no real violation. See, this is coming in the domain of fair use.
Okay.
This is coming in the domain of fair use. If I want to judge the capability of a singer. Either the singer should sing the classical rags that are there in the public domain, because they have all are out in the public domain. So I can only sing that. And you will have to judge me according to what I sing, or I sing an original composition, which is not possible for the lakhs and lakhs of people or the millions of people all over the world. So what will any aspiring singer do? Any aspiring singer is going to ride upon an existing song. However, to answer your question, what the courts of law have said is that if you're playing music in a hotel, or you are playing music in, let's say, a lounge, and you are drawing customers to that lounge or to that area, riding on the music that you're playing, then you have to give royalty to that. All right. So for example, let's say I say, I love to go to Taj. What's special about Taj? No, I just like the kind of music that they play, and I like the ambience that they create. So I like to go to Taj. So that means somewhere in my mind, it has registered that Taj is playing a kind of music which normally the other hotels are not playing. And my reason to come back to Taj is the music that they play. So we have created a route for commerce. At the end of the day, hotel industry, what does it want? It wants people to come back to it again and again. How will a lounge survive? A nightclub survive? Why did DJs become famous? They became famous because of the kind of music that they played. Now DJs have learned that they should take copyright on the selection of the music that they are playing, because that is their arrangement. So lots of things have come in over here.
So you mean to say the DJs or even music bands, when they play the music bands, when they perform the music of A.R. Rahman or any, so they need to take permission?
So there has been a kind of duality over here. There have been countries in the world which have now come out with a very strict thing which says that music bands should take permission of the original composer. But there are others who say that at the end of the day, what the music band is playing is their own composition. Means when I am changing little bit here and there, actually it is my version.
Okay, the remix is my version. Okay.
So actually, what has happened today, when I was telling you that copyright is the baby of the lot, when copyrights came, people all over the world treated copyrights as, this is meant for people of leisure, for poets and singers and artists who've got nothing else to do in life but to do all of this. They never imagined that copyrights would become one of the most complex intellectual properties. So many gray areas in copyrights that it is becoming very difficult to define boundaries and say, no, it belongs to so and so and it belongs to so and so. A lot has to be done.
Excuse me, ma'am.
Yes.
Ma'am, when we sign a non-disclosure agreement with a company, and if we use any of their information, like their financial information or their employee policy informations for research purpose, is it an infringement of any sort of copyright or of any sort of information or anything in that way?
I'm going to answer that question very simply with exactly what is contract.
Okay.
Generally, non-disclosure is being determined by your contract between the two parties. Hello?
Yes, ma'am.
Am I not audible?
Yes, ma'am, you are.
So, based on what the two parties have written in the contract, the non-disclosure will be determined according to that. Now, when you are writing, when we are preparing a non-disclosure agreement, we specify very clearly what will be under the category of confidential information.
Right.
So, if I have specified very categorically that X, Y, Z, A, B, C will be part of confidential information, then whether you choose to call it fair use or not fair use, if you have used it, you are guilty of infringing my confidential information. Very
Okay.
simple.
Thank you.
So when we use confidential information, that's why people always elaborately in non-disclosures write down what will constitute.
Right. Okay.
Okay.
Thank you.
We can take one more question if anybody has.
Can I?
Yes, Stani, the last question,
Yes, please.
because of paucity of time.
So, in case I'm only talking about copyright, if I have to register a copyright in my name for any work, I mean, what would be the cost or what would be the time it would take? So for everyone's knowledge, if
So copyright in terms of registration is fairly simple. So the statutory costs, that is, the government takes a cost for all IPs. For every IP, there is a statutory cost, and then there are professional costs. So the statutory cost for anything in print is 500 rupees. All right. So that is, and the lawyer who is helping you to file the copyright, whatever he or she takes, and which cannot be beyond, it's not an exorbitant amount, because copyright is fairly simple. How much time it takes to get copyright? Earlier, it used to take a lot of time. Now, ever since the copyright vertical has come under DIP, things have been streamlined and the process is pretty fast. So within 1.5 to 2 years, you can get the registration. But the point that we are making over here is, once you have applied for a copyright and a trademark registration, you can safely say, use the symbols for the IP right. So if for any work at any point of time that you are writing and it's an original work of yours, then never omit to use the C in circle variant and put the year and your name, so that very clearly it is established that you are the author of the work, whether you have got this registered or not, immaterial. But once you put that public declaration, you are safe in terms of copyright protection.
Thank you, ma'am. Thank you, Professor Stani. Now I invite Dr. Binubi Paul to render the vote of thanks.
Thank you, Soumya. So before I proceed with my formal task of rendering the vote of thanks to Dr. Anuradha, let me be very honest. I had no intention of listening to the entire session. I had no intention of paying attention on a Saturday, especially given the nice climate that we have in Lavasa. But I think you've done a fantastic job of engaging everybody. I think your examples were really, really current. It actually would appeal to the kind of crowd that you're listening to. And I must also say that some part of the conversation actually took me back to my university days, where I first heard about this term in a seminar. Of course, when you're a student in university, you don't go to a seminar to listen to speakers. You basically go there for the good lunch. That was the primary idea when I went for the seminar. But this gentleman by the name Dr. N.S. Gopalakrishnan, he did a fantastic job of introducing this. And I think, oh, okay. Yeah, so NSD and a couple of his students, I think they did a very, very good job. In fact, two of them are very, very close friends. The discussions that we had from there, it stretched to my university hostel, where people were trying to discuss about the philosophical underpinnings of having something like IPR. This, I think, is way back in 2004 or 6. I think it's around that time. So people were very bothered about, some of my very strong left-leaning friends were very bothered about the possibilities of rent-seeking behavior and the consequent social impact it can have on, as a result of IPs. And I was very, very, very interested to listen to the examples that you brought, like GOT, for instance, or Harry Potter, for instance. You actually don't listen to those kind of examples in a typical seminar. So I think it was really, really engaging, very, very elegantly put, very succinctly represented the entire, whatever that is required for a beginner to understand. And I'm sure that my students, the students at the university who are, I'm assuming that a lot of MBA students have also joined the program, you probably would now want to look at possible dimensions of copyrights and their infringements when you invest a lot of money in this. Like, for instance, the moment when you ask an advertising agency to create a brand, a logo or a tagline for you, it's like sunk investment. You can't do anything with it. For instance, so if you pay, let's say, Linktas X amount of money to come up with a brand or a tagline, and if it does not really work very well, it has happened, then you are actually losing a lot of money. So the possibilities in which the possible dimensions or the economic dimensions of copyrights and other things, I'm sure my students will keep in mind. So I think it was an academically well spent forenoon on a Saturday. Thank you very much for that, Dr. Anuradha. So now let me get to the formal part of it. I would like to, this is the boring part, but on this I think I'm supposed to do it. So I would like to place on record our sincere appreciation to Dr. Anuradha Maheshwari for having engaged all the participants in a very, very nice conversational style presentation on IPR. I'd like to thank Dr. Father Josie Josh, who is the director of the campus, Dr. Father Arun Anthony, who is the academic coordinator, Dr. Becky Thomas, who arranged everything and also asked me if I could render the word of thanks. I mean, if he had not asked me, I would have not really had the opportunity to listen to Dr. Maheshwari. I would like to also thank the IT support team and all the participants and also the ones who asked questions to keep the the discussions entirely engaging. And I really hope, and I honestly hope that we have a bit more of, let's say, time to have a detailed discussion at a later point of time, if at all, if time permits. Maybe if once everything gets back to what was pre-COVID levels of normalcy, if we could have Dr. Anuradha in the campus, I'm sure it's going to be a wonderful opportunity for the students to interact. So thank you so much, and I hope everybody stays safe. And once again, thank you, Dr. Anuradha Maheshwari.
Thank you. It was a pleasure. It was an honor. And I really enjoy talking about IPR because it is a subject of, interest and my passion. So I guess that's why. Thank you. Thank you so much, all of you, for inviting me.
Thank you, ma'am. Thank you, everybody. Before we wind up the session, let us all rise for the university anthem.
Strong, march on, Christ.
Thank you, Anuradha ma'am. Thank you so very much. It was such a delight seeing you again and listening to you. It is always a pleasure, and really, really thank you for. You spoke for so long, and I asked Soumya to ask you if you want a break in between.
No, we are very used to it, except that now that we're sitting at home, the throat buckles, not used to speaking. So
really appreciate it. And ma'am, I would like to reiterate what Binu said. You have to come and visit us on campus.
Surely. I would love to take this opportunity to visit you all at Lavasa, since I have not seen it. So
it's an open invitation, ma'am.